Good afternoon. I am Carrie Hunt, NAFCU's General Counsel. I'm here today to give you an update on Interchange. Earlier today, I attended a hearing in the case of NAFCU versus the Board of Governors of Federal Reserve. This is the long name for the Interchange lawsuit that we all have been following. It is a wild hearing, but before I get to that, let me give you a little bit more background and some history and make sure we are all on the same page so we can understand what happened today. So back on July 31, just a few short days ago, Judge Leon of the U.S. District Court for the District of Columbia granted summary judgment in favor of a group of retailers and retail trade associations called NAFCU in their lawsuit they had filed to overturn the final rule of the Federal Reserve had issued relative to interchange, and that's called Regulation II. If you may recall, that rule governed two different types of issues that came out of the Durbin Amendment from Dodd-Frank. For credit unions 10 billion and above, that rule had a limitation on the amount of fees that can be charged for interchange transactions. The Federal Reserve's rule ended up in a 21 to 23 cent range, depending on fraud costs. And that rule also outlined some provisions out of Dodd-Frank governing non-exclusivity. So the Federal Reserve issued that rule. It's been in place for quite some time, and then the merchants filed this lawsuit. Now, we had a hearing back in October. The judge a long time considered how to rule, and then finally on summary judgment in July we had his decision. Now, this opinion is highly critical of the Board of Governors of the Federal Reserve. I've never quite seen an opinion with so many exclamation marks in it, and the tone was quite dismissive. So where we are right now is if this court's opinion, which hasn't formally been finalized yet but will be soon, is not appealed or upheld on appeal, the board is going to have to make extensive changes to their regulations relative to the Durbin Amendment. So ultimately, credit unions could end up, if you are 10 billion above, back in that 7 to 12 cent range. And ultimately, NAFCU believes that due to market forces, issuers that technically don't fall under this rule will feel a big impact on the income they receive from interchange as well. So having concluded that the board's interchange transaction fee and debit card network non-exclusivity regulations were invalid, the district court held that the board should take another look at that rule, so they vacated the rule but put a stay on getting rid of that rule until the parties could resolve a couple of issues. And those were the appropriate length of the stay, so how long should we wait until the Federal Reserve issues a new rule, and also whether the board should develop interim standards, commonly called in administrative law, administrative interim final rule, until they can issue a final rule. The court wanted supplemental briefing on those matters, and it felt inclined that a stay of a couple of months should be appropriate rather than a lengthier time period. So in this order accompanying that opinion, the district court set a status conference for August 14th to discuss those issues. So now that the court had its opinion as to what should occur, how do we actually implement that? How soon does the Federal Reserve need to issue a rule? What are some of those tangential issues? And that brought us to the hearing that we had today on August 14th. Now, I just said that it was quite a wild hearing, and that's for a couple of reasons. In general, it was understood by the parties to just really establish a briefing schedule where everyone could figure out how to discuss those issues that he had raised in his opinion. So, whether there should be an interim rule and what that should look like. But during the scheduling conference, Judge Leon expressed open frustration at the Board of Governors attorney that she was not ready today to discuss the substance of those issues as to whether or not we should see an interim rule. Now, for the first time, the judge also raised the question as to whether it was appropriate to disgorge revenue that financial institutions would have received during the time that the Federal Reserve's rule was in place. Keep in mind the judge believes that the Federal Reserve issued that rule illegally because he struck down that rule as invalid. Now, the issue of whether or not profits should be disgorged was not something that was raised in any of the briefings. This is the first time that this issue has come up and certainly came as a surprise to everyone. Now, the judge did say that he would allow the amici in this case, of which NAFCU was one, to file briefs weighing in on both of those issues, whether or not the Federal Reserve should issue an interim final rule and how long that should be, and also on the issue of damages. And while no final decision has been made, I anticipate that NAFCU will participate to the fullest extent that we possibly can and express our opinion on those issues. There's some very strong legal arguments as to why it's not appropriate and the court doesn't have authority to address any sort of damages or disgorgement at this point in time. So in terms of next steps, the judge has left the current stay in place until next week, when he ordered the Federal Reserve's General Counsel Scott Alvarez to appear in person. Today, just the Associate General Counsel of the Federal Reserve was there to discuss the specific issue of whether or not the Federal Reserve should issue an interim final rule. The judge said is also going to have another hearing on whether or not there should be a remedy including disgorgement of profits, and that is going to be in September. So what does that mean for credit unions? Well, in short, for right now, the current rules and interchange are in place. It remains to be seen how long that is going to last. In part, it depends on Judge Leon. Hopefully the Federal Reserve won't get under his skin anymore. Reading the tea leaves, I do think that it's Judge Leon's preferred course of action for the Fed to issue an interim final rule with a really short comment period. So again, we're back to that leaning towards things could change within a couple of months as opposed to a longer period of time. Now, what that rule would look like and whether or not there would be a long implementation date for that remains to be seen as well. And that's something that we certainly would be strongly weighing in on. Now, the Federal Reserve is also still in the process of deciding whether it wants to formally appeal the decision of Judge Leon. So he has to enter a final order in this matter, and as a federal agency, the Federal Reserve gets 60 days to decide whether or not they are going to appeal. Based on other issues in this case, we think that they will come to that decision much sooner than that, and then once they appeal the matter, it remains to be seen what will happen with the stay as well. So in terms of what's going to happen next week, I think the Fed may or may not have decided as to whether or not to appeal. And even if they have, they may or may not reveal that decision by next week's point in time. So in the weeks to come, there are a number of weighty issues to address. Whether the Fed will appear, whether we'll have a final interim rule, and if so, what it is going to look like. I just want to assure you that NAFCU, under Dan Berger's leadership, is committed to exploring all of the avenues that we possibly can to produce a positive result for credit unions, whether it be through the court system or back with Congress or with the regulator. As always, please feel free to call me at any time. 703-842-2234. I'll be happy to answer more questions, or shoot me an email at chunt@nafcu.org, and we will continue to provide you updates as we have them via, of course, our NAFCU Today, our member communications, and any other way that you all need for us to make sure that you get your questions answered. Thank you very much.